Aloha and good afternoon. For the employer in Hawaii, there are complex regulations and statutes governing employment. It is an area of the law, employment, that is very complex, and although the employer may have good intentions, if the employer does not comply with the statutes and regulations, the employer may fall into an unintended trap. The theme this afternoon is employment, hot button issues. And my guest this afternoon is Sarah Wang. And Sarah, briefly tell us about your professional background and maybe your educational background.
Sure.
To start.
Sure, Roy. Thank you very much for having me. I grew up in Hilo and then went away for my education for college and law school.
I didn't know that.
I did. I'm a Hilo girl who spent 11 years on the mainland.
Right.
So I went to law school at the University of Virginia and
Right.
then had the privilege of clerking for a Ninth Circuit judge for a year after that.
In San Francisco.
His wife liked to ski, so his chambers were in Reno.
Oh, I see.
Very close to Tahoe.
Right.
And then I came back to Hawaii and started my practicing law in the area of just general civil litigation.
Right.
After about 2.5 years of that, I was fortunate enough to join my current law firm, which does exclusively management side labor and employment law. So
the name of the firm.
It's Marr, Jones and Wang.
Mm-hmm.
And so we do only management side labor and employment law. And I enjoy, as a big part of my practice, doing a lot of preventive, proactive work with employers, helping to make sure that they are familiar with what seem to be ever-changing laws and regulations, and making sure that their supervisors are well-trained to try and make good, sound, supportable employment decisions.
Sarah, to start our session this afternoon, maybe you can tell us briefly what are important matters that an employer ought to be aware of in hiring someone in the state of Hawaii?
Yeah, and that's a great way to start, because really, if employers hire the right employees in the first place, they hopefully won't need a lawyer for any other aspect of the employment relationship. They'll have a good employee who will be productive and work hard for them and do a good job. I think a lot of employers are familiar in general with discrimination statutes and the concept that employers are not allowed to make discriminatory decisions, whether it be hiring decisions or other decisions once they've brought somebody in as an employee. But Hawaii does have some special rules in that regard, and I think that's one of the places where employers sometimes get tripped up here, because what Hawaii does...
May I stop?
Yes, absolutely.
Those unique laws, they're state laws that you speak of.
That's correct.
Not necessarily federal laws.
That's correct.
Right.
I am speaking specifically of Hawaii state law.
Right.
And Hawaii's version of the anti-discrimination statute does prohibit making discriminatory decisions, which I think most employers are familiar with. But what Hawaii's law does is it goes beyond that, and it actually says that as part of your hiring process, your application and your hiring process, you're really not supposed to even talk about legally protected categories. So for example, a lot of employers may have a job application, and I haven't done this check in a few years, but at one point several years ago, it was the case that under 49 states and federal law, a particular question, as long as it was phrased correctly, asking an applicant on a job application about their conviction history was permissible. Hawaii would be the one state where that was not permissible. So in Hawaii, unless you fall into certain industries, in general, Hawaii employers cannot ask about convictions at all on job applications. In addition, during a hiring process, so during an interview process, even if you talk about a protected category, you ask someone, what an interesting accent you have. What's your ethnic background? Or you say, hey, I noticed you went to this Hilo High School, the same high school I went to. What year did you graduate? So that you can find out maybe if you have people that you know in common or some common interests. You put the applicant at ease. Those are actually illegal questions in Hawaii.
Why would that be illegal, Sarah?
Because with respect to the what year did you graduate from high school, that is viewed as relating to age.
All right.
And age is a legally protected category.
Yes.
Asking about a conviction
Yes.
on the job application relates to somebody's arrest and court record, which is also a protected category under Hawaii law. And that's different than the rules and the protected categories under federal law.
Wouldn't that have some bearing if you were to be the cashier of a company? Wouldn't that have great bearing on your prior criminal record?
So in Hawaii, I think probably the criminal record as well as a potential credit history or credit check might be something an employer would want to do for someone applying for a cashiering position.
Right.
In both of those situations, what Hawaii law says is that at the early stages of the hiring process, so on the job application or when you're still interviewing a number of different candidates, those are not permissible questions to ask. It's not permissible to ask about convictions, it's not permissible to ask about somebody's credit history, and it's not permissible to pull a credit report. However, once an employer has decided that they want to make an offer of employment to a particular individual, they can make that offer contingent or conditional on the applicant passing certain things, including a conviction check and including a credit history or credit report check, as long as there is a rational relationship.
Sarah, let me interrupt you there.
Yeah.
So at that point when you are considering hiring someone, you would ask that applicant, may I have a credit check on your background?
I think what you would actually do, or what I would recommend that an employer do, is when they make their decision of who they think they want to hire, they actually, you know, I'm a lawyer, right? So I like documentation.
Right.
So I would actually recommend that a formal conditional offer letter be sent to the applicant saying, hey, we think we want to hire you. We're offering you this position, but our offer is conditional on you passing, and then you list whatever it is that you want them to pass. There's certain things that can only be done after the conditional offer. The conviction check is one, the credit history or credit report for an appropriate position is another. And if some employers want to conduct a post-offer medical examination, that would be a third thing that can only be done after the conditional offer of employment has been extended. And then what the employer would do is if one of those conditions was not satisfied, at that point the employer would then withdraw the conditional offer of employment.
I see.
Yep.
And if the applicant were to say, no, I don't want you to conduct a credit check on me, he's not considered.
Correct.
I see.
Correct.
But you have gone through the process.
Right.
Now, what about age? You know, age has become a very sensitive matter. Say that the job is for a highly physically demanding job. You interview the applicant and he seems to be physically capable of handling that job. But later you find that after even before the end of the probation period, that the employee is not up to par, for the lack of a term, I would say up to par. Could that employee then be discharged?
Well, there's a whole lot of potential issues in that situation. So the answer, which I know is an answer that many employers hate, is maybe or it depends. It really is going to depend on the situation. So it's absolutely, I think, the best practice for employers to focus on performance. How is this applicant, or I'm sorry, this is a new employee, so how is this employee doing in the job? Are they able to meet my legitimate, performance expectations? And so I think that's one point that's prudent for employers to do. I think another point, you mentioned a probationary period. It's absolutely prudent for employers to focus on these issues early in an employee's tenure. You don't wait until they've been with you for 2 years to suddenly say, there's a problem. Now, a probationary period, I do want to make sure employers understand that a probationary period is not some magic period where employers have carte blanche to do whatever they want. I mean, all of the normal laws still apply during that period. It's just that as a practical matter, employees and their potential attorneys may be less likely to feel like there's been something wrong done to them because they understand up front that that is kind of a test period. We're trying to see if this is going to work out. So I think those are really good points. And then I think really the the performance ought to be the issue. So whether the person is an older worker, whether the
Right.
person is a female, whether the person has a medical condition, the focus should be on performance
I
and whether
see.
or not the employee can do the job. The only caveat that I would put in there, because if the employee can't do the job, typically an employer is empowered to say, look, you're not able to do the job, we're going to let you go.
Oh, I see.
The caveat is going to be the third protected category I mentioned. So I mentioned age, I mentioned gender, and then I mentioned physical or mental disability.
Right.
So it may be the case in certain circumstances where that employee will say, well, the reason I can't do the job is because I have this health condition. I have this physical or mental condition that's making it
Right.
difficult. The law in certain circumstances does require employers to provide a reasonable accommodation.
Oh.
So in those circumstances, and one of them is a physical or mental disability, Hawaii law also imposes an accommodation obligation for pregnancy, childbirth, and related medical conditions. So if an employee says, well, the reason I can't do that is because of my pregnancy,
Right.
similar to the reason I can't do that is because of this health condition, an employer really can't just terminate without going through a process of saying, well, is there a reasonable accommodation we could provide you that would enable you to do the job? And a reasonable accommodation really can run the gamut of things. It can be providing tools or changing processes a little bit to enable the employee to do their existing job. It could be providing the employee with a period of time off, a leave of absence. So maybe an employee says, well, I injured my shoulder.
Right.
It's not a workers' comp injury. I injured it off
Right.
work, but I need to have surgery on it. Once I have surgery, I'm going to be able to lift all these things you want me to lift as part of my job, but right now I can't until I have the surgery. I need 2 months off for surgery and rehabilitation. It might be, depending on the circumstances, that time off could be a reasonable accommodation.
Sarah,
Yes.
2 questions.
Yes.
Probation. What is the normal probation period in Hawaii?
Yep.
Usually it's 3 months, it's
It-
my
it-
understanding.
Yeah, and it really depends. So probationary periods are very, very common in unionized context. So if there is an employer who has a collective bargaining agreement with a union, it's very likely that collective bargaining agreement will have 60, 90, 120 days.
I
That's
see.
something in that
Right.
range as a probationary period. And I will say, sort of as a caveat to what I mentioned earlier, in the union context, there really is a little bit more teeth to that probationary period, because typically during the probationary period, a union employee does not have recourse to their grievance system under the CBA.
I see.
So, but it's typically in the union context, that's pretty common. And I think most employers, a lot of employers won't call it a probationary period because they don't want to give the implication that once you get through the probationary period, you've now
Right.
got a permanent job.
Right.
So a lot of employers call it an introductory period or an orientation period. But semantics aside, I think typically in the non-union context still, I think you're right. 3 months, 90
months.
days is pretty
And
typical.
the essence, whatever you call it, is still a probation period. Now, the second question I had on your comment is, say the employee says, I need 2 months to go through the surgery and recovery process. 2 months is a long time. And during that period, the employer cannot hire someone else to replace the employee who is on I guess, sick leave or whatever. It doesn't seem to me a reasonable time for an employer to give to the new employee. What is your take on that?
So I think one of the most important points to recognize is that I am definitely not suggesting that 2 months is necessarily going to be a reasonable accommodation. One of the things that I think is most difficult for employers is that all of these issues, the reasonable accommodation issues based on health conditions, they really require a case-by-case analysis, and they really are going to depend on the facts and circumstances of a case. So I can imagine employers, and I've seen employers, who, as a rule of thumb, do typically provide for leaves of absence that may range up to 3 months. If an employer already has that policy where they will grant in their discretion leaves of up to 3 months, it becomes difficult for the employer to say, well, a 2-month leave is unreasonable.
I see.
Similarly, if it's a position that's very easy to replace on a temporary basis, maybe it's a clerical position and it's very easy to bring a temp in who can cover for that 2-month period, that might be reasonable. Whereas bringing someone in for a higher level or a more specialized kind of position, you might not be able to do that. And so giving that person a 2-month leave of absence might not be reasonable.
Well, let's move on here. Sarah, there are employees who are constantly absent, the absentee employee. What if we have an employee who is constantly absent and he or she comes in with a required doctor's certificate saying, I have treated that person and he or she was ill, but that employee constantly, I use the word constantly, is absent. Is there a justification for the employer to say, this is enough, I cannot take it anymore? You're always absent.
Yep.
What is the suggestion to the employer in such a case?
So I think a lot of employers have to deal with that situation and do get frustrated with that situation. And so what we've seen is, I think, an increasing number of employers who go to what we call no-fault attendance policies. And what that means is, look, employee, we're not saying that you're lying about your need for sick leave. We're not saying that you're faking it. You know, we understand that you are legitimately sick. You've got a doctor's note to validate it.
Right.
But still, part of the requirement for this job is regular and predictable attendance. We need you to be here.
Right.
That's a requirement. Hopefully the employer's job description includes that as a requirement for the job so that the employee is on notice.
Yeah.
And then the general rule is, and of course, again, with if there is a union situation, you do have to take all of this with a grain of salt, because with a union, you could not just put one of those policies in place. You'd have to negotiate it or confer with the union. But in a non-union setting, employers who want to have that kind of a no-fault attendance policy, who basically want to say, look, if you've got X number of last-minute, unexcused absences, unscheduled absences within a certain period, you're going to be disciplined for it. And we're not saying you're lying about your absences. We're just saying we need you here. That generally is going to be permissible, with the caveat that an employer cannot discipline for certain legally protected absences.
Such as?
So for larger employers, if an employer has 50 employees, they within a 75-mile radius, they're going to be covered by the Family and Medical Leave Act.
What is that, a federal or
That's
state?
a federal law. If they have 100 employees in the state of Hawaii, they'll be covered by the Hawaii Family Leave Law, so that's a Hawaii law. All Hawaii employers are covered by the pregnancy regulations. So an absence that's related to pregnancy, childbirth, or related medical conditions, an absence that's covered by the Federal Family and Medical Leave Act or the Hawaii Family Leave Law, those would all be absences that could not count against an employee under a no-fault attendance policy. Military leave would be another example.
Oh, let me just stop you here. If there are any viewers who have questions, please tweet. Please tweet us at ThinkTech Hawaii. Yes.
Aloha, my name is Josh Green. I'm a senator from the Big Island. I work in the ER there. But on Tuesday afternoons, I get to come and spend 45 minutes to an hour with Jay Fidel and the ThinkTech staff. They're terrific professionals. They help us to bring some of the leading cutting-edge topics here across our state to you. So you can join us at our show on healthcare in Hawaii to talk with leaders from across all the spectrum of health in our state, or you can join us for any other show where we talk about economic development or tourism or some really eclectic programs too. So really, we'd love to see you here on our show. Thanks for joining us and thanks for supporting us.
Flying through.
Yeah. So.
Aloha, my name is Josh Green. I'm a senator from the Big Island. I work in the ER there. But on Tuesday afternoons, I get to come and spend 45 minutes to an hour with Jay Fidel and the ThinkTech staff. They're terrific professionals. They help us to bring some of the leading cutting-edge topics here across our state to you. So you can join us at our show on healthcare in Hawaii to talk with leaders from across all the spectrum of health in our state, or you can join us for any other show where we talk about economic development or tourism or some really eclectic programs too. So really, we'd love to see you here on our show. Thanks for joining us and thanks for supporting us.
Aloha, and this afternoon our guest is Sarah Wang. Our topic is employment, the hot button issues. Sarah, let us talk about pay and salary, which is a very important issue that comes up constantly. For our viewing public, tell us what is the current minimum wage? Because in reading the newspaper and over the television, I see all kinds of different numbers. So maybe you can tell us, and which is applicable in Hawaii.
Yes, and that sounds like a very simple question, and unfortunately there are a few nuances, so it's going to be a little bit longer of an answer than you're probably expecting.
All right.
So most Hawaii employers are going to be covered by both federal and state law.
How can that be?
Because there are different thresholds for what is required to be covered, and most employers are going to meet both of them. So most employers will be covered under both federal and state law. In terms of what the minimum wage is, the laws both basically provide that whichever one is better for the employee is the one that applies. Yes, so basically the higher wage is the one that applies.
I see.
So one of the reasons that here in Hawaii we have seen, I think, a lot of numbers, when you read the paper you see a lot of numbers, is because the Hawaii legislature a couple years ago gave us a stair step. So they've already told us what the minimum wage is going to increase to over the next several years. So currently in Hawaii, unless you're a federal government contractor, in which case I will give you a caveat of some new rules that apply, but unless you're a government contractor, for those government contracts, the minimum wage currently is $7.75.
$7.75.
Yep,
yes.
for non-exempt employees.
Right.
Now that's already scheduled to increase. So come January 1 of 2016, that's going to go up to $8.50. Come January 1st of 2017, it will go up to $9.25.
I see.
And come January 1st of 2018, it will go up to $10.10. Now, for federal government contractors, on certain contracts that were either solicited or in some cases issued after January 1st of 2015, those contractors already are required to pay $10.10 for workers on those contracts.
Even if it's not 2017.
Correct, because this is specific to the federal government contractors on contracts that are covered by an executive order that President Obama issued that really only is going to apply to federal government contractors, not to all employers.
All right. And is there any law or regulation covering part-time employees? Or is it the same as a regular employee?
So it's going to be the same in terms of the minimum wage. So minimum wage, part-time or full-time, it doesn't matter. The minimum wage on an hourly basis is still the same.
Right.
If you have someone who is typically a part-time employee, so in the vast run of weeks, let's say they work 20 to 25 hours.
All right.
But in a particular week, let's say you're understaffed, that part-time employee, you need to pull them in to work extra hours.
All right.
And if that part-time...
What do you mean extra hours?
So let's say, again, you've got a part-timer that you generally will work 20 to 25 hours a week.
Right.
But in a particular week, you bring them in on extra shifts. They're available, you need some manpower, additional manpower, you bring them in.
Right.
During that week, if they end up working over 40 hours in the work week, even though they're classified as a part-time employee, they're assuming they're a non-exempt employee, they're still going to be entitled to overtime pay for all hours they work in excess of 40 during that week. It doesn't matter, let's say you've got a 2-week pay period, so it doesn't matter that over the course of the entire 2-week pay period, maybe they only average 32 hours per week. That doesn't matter. If one of the weeks they work over 40, they have to be paid overtime for the time over 40.
Now tell us, what is the standard for computing overtime?
So again, if you have a collective bargaining agreement, it's going to be different because collective bargaining agreements often are more generous than what the minimum legal requirement is. But in Hawaii, it's a little easier than for California employers and employers elsewhere where their states have come up with special rules. Hawaii's rules really mirror the federal rules. So Hawaii employers really just need to know one rule, and that is You have a particular 7-day work week that the employer sets, and if the employer doesn't set
Yeah.
one, then there's a basic default, Sunday through Saturday. If a non-exempt employee works more than 40 hours during a work week, they have to be paid time and 1/2 their regular rate of pay.
I see. And that is, no question, time and a half.
Time and a half. An employer is always free to do more, and if a collective bargaining agreement calls for double time, the employer has to do that.
Yeah.
But the legal standard is time and 1/2.
Okay.
One place that employers sometimes get in trouble is they think, well, I'm a very generous employer. I really compensate my employees well.
All right.
And so I pay them so well that they must be exempt. They must be exempt from the minimum wage and the overtime requirements because I pay them so well.
Mm-hmm.
If that and that's not right. That's not how the exemptions work, for the most part, or that's not how many of the exemptions work. And so, if an employer gets that wrong,
Yes.
then what it means that they are paying so much to these non-exempt employees just means that their overtime rate is that much higher because now they have to pay time and a half
Based
of,
on-
of their very high basic rate.
Oh, so the employer has to be extremely careful.
Yes. And employers should be paying close attention right now because within the next few months, the Department of Labor, Federal Department of Labor, is expected to issue new regulations that will narrow the number of employees who are going to be classified as exempt under federal law. So there are different exemptions under federal and state law. Like I said earlier, most employers are covered by both federal and state law. So in order to find an employee to be exempt from being paid the minimum wage and being paid overtime, that employee has to meet an exemption under both laws, under both federal and state. And the federal exemptions, what we call the white collar exemptions, they're
Right.
the administrative, the professional, the managerial, or the executive
Right.
exemptions, those are narrowing. So fewer employees are going to be covered. Currently, in order to be covered, one of the requirements is you have to be paid at least $455 per week. The proposal by the Department of Labor is to increase that to a figure that is estimated to be $970 per week.
Per week.
Per week. That's
Per
over
week.
$50,000 annually. Now, that's just the proposed regulations.
Yeah.
That's not final yet.
Right, right.
And so we do have to wait to see what the final regulations will do. But my prediction is that it's going to raise that salary basis requirement, and it's going to ultimately then have the effect of narrowing the number of employees who are going to meet those white-collar exemptions.
Now, Sarah, another thing which seems to be a magic number is 20 hours. When employers talk in Hawaii, somehow 20 comes up often.
Yes.
And why? But today you say 20 to 25.
And I was just making that number up.
Oh,
so
I see.
I know what you're going for. I think I know what the issue is for many employers in Hawaii. Why 20?
Right.
And it's because under Hawaii law, we have the Prepaid Healthcare Act. And the Prepaid Healthcare Act requires employers to provide coverage for employees who have worked 20 or more hours for 4 consecutive work weeks. So I think that's probably where the 20 hours comes in.
I see. Now, let me ask, many times, let's be candid about this, many companies are in a financial strait. I mean, they seem to be very busy, but their profit margin is very small. So they would ask their employees, can you take time off instead of us paying you for your overtime work or whatever? Is that permissible, number one?
It depends. Again, lawyer's favorite answer.
Yeah.
If what an employer wants to do is prevent an employee from getting to the overtime hours. So in
Yes.
other words, you've got an employee who
Right.
normally works Monday through Friday, 8 hours a day, right? So
Right.
normally works 40 hours in a week.
Right.
And so you don't normally pay them overtime.
Right.
Well, there's just a big project that's due on Thursday. And so they end up working an extra 4 hours on Thursday. We haven't gotten through the work week yet because we still
Right,
have Friday.
Right.
If the employer says, look, I want you to take 4 hours off on Friday. I only want you to work 4 hours on Friday
All right.
so that at the end of the week, they've still only worked 40 hours.
Right.
That's fine. Okay, that's okay.
Okay.
But if what the employer wants to do is now they look back, we finished the work week, and it turns out that employee has worked 44 hours. And what the employer wants to do is say, okay, instead of me paying you those extra 4 hours of overtime, I'll give you time off.
Right.
In fact, I'll even give you time and a half off. So instead of 4 hours off, I'll give you 6 hours off. We'll treat it as time and a half. Can I do that? Sounds logical. A lot of employers call that compensatory time or comp time.
Comp time, yeah.
If it's a private employer,
Right.
it's not allowed.
Oh, it's not
It
allowed?
is not allowed, no.
There is a prohibition?
There is a prohibition. So there are special rules that allow public employers
Yeah.
to use comp time in certain circumstances. Not all the time, you have to meet certain requirements, but private employers cannot.
We are going to take another break here. You know.
Okay. I've rocked you back on your heels with that information.
You have. Because I think it's a common practice in Hawaii. If any of you have questions, please feel free to tweet us at ThinkTech Hawaii. Thank you. Oh.
Hi, I'm Jay Fidel. I'm host of Hawaii, the State of Clean Energy, which is our flagship show, which plays 4 to 5 p.m. every Wednesday. And the supporters of that show are Hawaii Energy Policy Forum and Hawaii Energy. And luckily enough, we have representatives of both of them right here today to tell you more about what they think about the show. Sharon Moriwaki at my left is co-chair of Hawaii Energy Policy Forum, and she goes first. Sharon?
Thank you. Thank you, Jay. I'm so glad that we have this Hawaii, the State of Clean Energy. This was 2 years ago when we started this, and we have continued it because it's so important, and there's so many developments happening across the state. And we hope you'll tune in every Wednesday, 4 to 5. It's wonderful.
And Ray is Hawaii Energy. Ray, what is your thought about the same subject?
Well, I agree completely with Sharon that we are talking about every Wednesday, 4 to 5. We talk about some of the most important subjects that are affecting the islands now and into the future. Energy, clean energy, we need it. We often run into new ideas that we had not thought about before. We did just today, and I think we're going to have more of that in the future. So come on down and watch us 4 to 5 on Wednesdays, and we'll see what happens.
We'll see you then. Aloha.
Aloha.
Aloha, and we're back again with Sarah Wang. Our theme today is employment, the hot button issues. Before we went on our break, Sarah, we were talking about compensation here. One of the questions which is a important thing for families is holidays. Sure. Most employees want to know what holidays they're entitled to. Let me ask you, is there a Hawaii statute that says that an employee is entitled to 5 holidays or 6 holidays or whatever?
There is not. There is no statutory requirement, again, putting collective bargaining agreements aside,
Right.
because those almost certainly will have holidays worked into them.
Right.
But holidays are not, there's not a statutory obligation for employers to provide that. Most employers do. I think that's probably more of a competitive issue. They want to be able to compete for good employees, and I think employees look for things like that.
Right.
What are the benefits that are available if
Right.
I come to work for a particular employer? But there's no statutory requirement. I generally recommend that if an employer does decide to provide paid holidays, and most employers do, that they think through the terms on which they're going to provide it. What if an employee ends up working on the holiday instead of taking the holiday off? Do they get holiday pay plus the hours worked? Do they get paid at time and a half for coming in on a holiday? What happens to holidays that fall during a vacation, or a holiday that falls when somebody is sick? In order to get holiday pay, do you have to work the regularly scheduled workday before and after the holiday in order to try to prevent misuse or abuse of the holidays? So I encourage employers who want to provide paid holidays to have a policy regarding the terms, but it's not required.
Sarah, on that point about holidays and giving notice to the employees, one of the things that I wanted to cover today, and I don't know if we'll have the time, is the company handbook.
Yes.
Do you suggest that the holiday matter also be included in the company handbook?
Yeah, if an employer has a company handbook,
Right.
And I tend to fall on the side of believing that that is a prudent practice to have a company handbook, then yes, I do think that the holiday policy, if employers want to provide paid time off for vacation
Right.
Or sick leave, that those types of policies, I would recommend they be in the employee handbook.
And in writing so that it would be a notice to the employee.
Right,
Let
and
me-
I think, I'm sorry to interrupt you, Roy.
Go ahead.
I was going to say, I think that there are really several good reasons for having those policies in an employee handbook. And one is, as you say, to provide the notice to the employee so that the employee knows what the company's expectations are, knows what
Right.
the company's benefits are, at least at the current time, what they are. I think it also sometimes, in some cases, it satisfies legal obligations. So the Department of Labor and Industrial Relations, for example, here in Hawaii, does take the position that although you don't have to provide sick leave or paid time off for vacation, if you are going to provide it, you should have a written policy for it. And so having that written policy in a handbook or otherwise satisfies that legal obligation.
see.
And then finally, I think that having the information in a handbook also helps your supervisors or those who have to administer the policies and have to enforce the rules, because it lays it out for them and it helps a company ensure that its policies and rules are going to be applied and enforced consistently. And so I think for that reason as well, it's a
see.
useful idea to have a handbook.
I would like to talk about handbooks more, but let's go on to another hot button issue, which is maternity leave, Sarah. Tell us what are the statute and regulations on maternity leave in Hawaii?
Yep. So Hawaii, under our pregnancy regulations, which are not in a statute, but they're found in the Hawaii Civil Rights Commission's regulations.
Oh, it's not a statutory provision.
It's not, this particular provision is not. So our statute specifically says that discrimination based on gender includes discrimination based on pregnancy. So that clearly pregnancy discrimination is prohibited by statute. And then the Hawaii Civil Rights Commission, which is the administrative agency that enforces that statute, they have written regulations that provide much more detailed requirements for employers.
All right.
So under those regulations, what they say is that a female employee who is disabled
Right.
due to pregnancy, childbirth, or related medical conditions is entitled to a job-protected leave for a reasonable period of time.
All right.
And then reasonable period of time is
Yes.
defined as the amount of time that the female employee's physician disables her from working.
Say that again.
A reasonable amount of time is
Time, yes.
defined as the amount of time that the employee's physician disables her from working due to pregnancy, childbirth,
That-
or related medical
That's
conditions.
a lot of power to the physician.
It is indeed.
And
So-
it would be across the board. It could be 1 month, 2 months, 3 months.
And that's one of the things that I think Hawaii employers sometimes do get tripped up on, because you expect
Right.
to see a hard and fast number. You
Right.
expect to see 3 months or
Right.
6 weeks or
Yeah.
something like that. And really, that's not how Hawaii law is written. Now, that's assuming that's the pregnancy leave or maternity leave that is caused by the female employee's inability to work, her disability due to pregnancy, childbirth, or related medical conditions.
What would be a related medical condition?
Potentially, if she has complications during her pregnancy.
Oh, I see. I see.
Potentially postpartum depression after childbirth. A lot of employers, though, will provide leave beyond just the period when the employee is disabled. So they might provide what they might call bonding leave, or sort of maternity leave in the sense of taking care of the newborn when the woman is actually released to return to work herself. In that case, I think one of the things employers need to be careful about is now going to be gender discrimination or some other type of discrimination.
In what respect?
So if an employer says, well, look, we will let a woman who's given birth, we will let her take some additional bonding leave time off beyond the time that her doctor disables her, but says, no, we're not going to allow a father
Right.
who wants to take time off for the same reason,
Right.
or a same-sex couple who is
Right.
adopted and who wants to take time off for the same reason. discrimination. If we're going to deny those other individuals the same time off that we would allow a birth mother,
Right.
then there's a risk of gender discrimination or sexual orientation discrimination or a claim like that.
So in the current conditions of society, it's becoming even more complex.
I think that's right.
Let me ask you this. Are there any case laws that would define what is a reasonable time for the mother to recuperate, for the lack of a term?
There really is not, at least not under Hawaii law. Other states may have different laws, but under Hawaii law, the regulations issued by the Hawaii Civil Rights Commission define it as the amount of time that's been certified.
I see.
This is a really difficult area for employers because under a lot of other statutes, employers who are covered by the Family and Medical Leave Act, the federal FMLA, for example, pregnancy is...
What is SMA?
I'm sorry, the FMLA, the
Yeah.
Family and Medical Leave Act.
I see.
Pregnancy is a covered condition under that act as well that would allow employees time off for a certain period of time. That law provides employers with opportunities to obtain pretty detailed medical certification, to obtain some amount of guidance from a physician in how much leave is likely to be required, the duration of the leave, and if the employer has a reason to doubt the validity of the certification or to question or feels like some of it is ambiguous,
Right.
there are certain remedies that the employer has to send the employee to a second opinion, for example.
I see.
The Americans with Disabilities Act similarly does that, but the Hawaii pregnancy regulations do not. And so employers really don't clearly have a lot of recourse if they feel like an employee's physician is really disabling her from work for an
I see.
unreasonably long time.
And the physician to be chosen would be a physician chosen by the employer.
In a case, so we're not talking about pregnancy because the pregnancy regulations do not have any provisions that would allow an employer to do that. But if we were talking about absences under the FMLA or medical conditions that would be
Right.
disabilities under
Right.
the Americans with Disabilities Act, those statutes would allow an employer to select their own physician.
Sarah, for the lack of time here, let us talk as much as we can on sexual harassment,
Okay.
which is, from my personal experience in counseling employers, this comes up quite often and is almost a costly matter for the employer. Within the brief time we have, why don't you take a few minutes to tell us what your advice to employers may be in this area?
Yep. So in Hawaii, sexual harassment is still the most common kind of harassment claim. Not true on the mainland. On the mainland, racial harassment claims are actually more common.
I see.
But sexual harassment here is still the most common type of claim, but it's certainly not the only type of harassment claim that employers see. So two of my biggest pieces of advice to employers is to have a good policy and to train your employees, especially your supervisory employees, on what your expectations are as a company for them to both recognize what I call risky behaviors, because I don't think an employer wants to wait until they actually think they have unlawful harassment in the workplace. I think they want their supervisors to deal with risky behavior. So I think they need to...
Could you give us an example of risky behavior?
Sure. So you've got employees who work really hard, and one employee goes over to another one trying to be helpful and starts massaging their shoulders.
I shouldn't laugh. But
Some employees think that's great. Other employees think that's physical touching that they are not comfortable with.
All right.
Hawaii-style hug and kiss.
Oh, right.
Right? A lot of employees in Hawaii workplaces are going to be fine with that.
Right.
Some employees, though, may say, wait a minute, I'm not comfortable having a coworker I hardly know come over and give me a hug and a kiss, and maybe
Right.
their hands lingered a little too long, or
Right.
maybe their hand rubbed a little bit, or, who knows what else was happening.
All right.
And so there's all kinds of behavior that could happen in the workplace that could be risky behavior. And I think that what an employer wants to do is train their supervisory employees to recognize and to facilitate communication about those issues. And then if a complaint comes up or if they observe something that they think crosses the line, be trained in what the company expects them to do. how does the company want to deal with that? So these days, I think some important aspects of a policy are not to have a sexual harassment policy. The policy should
Not to have one?
not to have a sexual harassment policy. So I think they should have a policy, but I think
Right.
it should be broader than just sexual harassment. I think it should prohibit harassment on any legally protected category. So just like you can have sexual harassment, you can have racial harassment, you can have age harassment, you can have sexual orientation harassment, religious harassment, and all of those should be clearly prohibited by an employer's policy.
Sarah, you have 50 seconds. Your last advice to employers within the 50 seconds.
So I think in addition, the one other thing I would say, because I think it's an important one, on the same topic of the harassment policy, it should be a broad harassment policy. It should err on the side of caution. It should not just be limited to prohibiting unlawful behavior, and it should give employees multiple avenues to make complaints. It should not limit the complaints only to the chain of command, the employee's immediate supervisor. There should be other options for the employee as well.
All right. I wish to thank you for coming. We haven't finished all of the topics I wish to cover. So, Sarah, I may ask you to come back and be my guest again. And I really appreciate all the informative information today. I really learned myself. So, thank you very much. And we hope to see you back again. Aloha and thank you very much.